Hey, it's James, Father's Rights and Resources, hashtag how I got custody. Going live on YouTube right here. And let me check, let me do the messages here. I see this one guy, Cole Robinson, weight loss. It's a snake diet guy. He gets on here and he stares in the camera for like 2 or 3 minutes waiting for people to get on. I don't want to do that and have a bunch of dead air here. So let me make sure I'm moderating this right. Okay. So I'm only letting subscribers get in here to ask questions and answers. So if you have a question or answer, you need to subscribe. And that way I limit the trolls too. So you can ask, we can do questions and answers if you have questions, or an issue. What's up, John? He said the GOAT. Actually, I'm not the GOAT at this. There's some people who are a lot better at this than me. Well, I guess I have my little niches. There are some people who are a lot better at certain things, like appeals, who are better than me, even in my area. But the one guy I actually have gotten advice from when I've done appeals, he's out here. Let me zoom in a little bit. Okay, he's out here, and he's out in the backwoods. He's kind of like the Yoda out here, I guess. So, super genius dude when it comes to appeals. He's helped a lot of dudes win appeals. He had some health issues, so he really faded out of the scene. There's a guy I know on the East Coast hey, Daniel, there's a guy I know on the East Coast who helps people with appeals. I don't know how much he helps directly on cases, but he does a lot of appeals. I think that's his passion. He used to work with Dads Against Discrimination. He's the only guy. Now, Dads Against Discrimination, you could go to dadsamerica.org, and you could see there's about 12 chapters across the country. They're all dead and gone and fizzled and faded out because most of the guys who do stuff like this, they only do it for a couple years, or even in the father's rights movement, except maybe the guy in Ohio who manages the whole Midwest region, which he might be like the national manager, but that guy's a total sellout. I'll tell you why in a minute if I remember. But anyway, dadsamerica.org fizzled out. The guys who ran it out of Portland, Washington, was headquartered. They all turned loony and stupid, and one guy's on his roof waiting for the UFOs to come rescue him and all kinds of stuff. But there's one guy in New Jersey that helps people in New York, New Jersey. I think he can do a lot of other East Coast states that he specializes in. But I think he mostly deals with appeals. I think he wants a couple $1,000s of a retainer, though. So I'd still trust that guy over an attorney, just from what I know that he knows. But there's I'm talking about this because some guy called me the GOAT in here, but there's other people who know. I mean, there's people who've done their own individual case, and they did so much research on it, and they were on top of it. They might be better at me at a lot of stuff, but they're choosing not to stick around and help other people out. So there's people who have done this without any guidance and figured it out on their own and did better than I did initially in my case. Probably it's even better and easier now because everything, there's AI, there's the internet. It's easier to access anything. It's easier than ever to access anything. So that might be part of it too. But I know there's thousands of people across this country who could help people with their experience, but don't, because they're burnt out. Family court's dysfunctional. They want to stay out of that cesspool. And there's a couple people who are around who did their thing for a while and they just got burnt out and got done with it. I know attorneys who are burnt out. It's crazy. In Washington State, There's probably 4 attorneys I've liked. Let me try and think. 1, 2, 3, 4. Maybe 5, because I used to work with her. I'd write up paperwork for clients, and then she'd go present it. She just let me do it all on my own. And it's kind of like, the paralegal attorney relationship is kind of like a nurse and a doctor. Nurses know a whole lot about medicine without going to med school, and they learn a lot just from firsthand doing it. But they can never perform surgery or do that all that technical stuff, even though they know just about everything. But when you have paralegals that are in the family law world, family law is so dysfunctional. These attorneys are such idiots. They follow the lead of those attorneys. We have a thing called triple LTs in Washington, LLLT, Legal License Liability Technician. They allowed paralegals to practice a limited amount of family law, prep people for trial, present ex parte motions, write up paperwork. But they had to take a whole bunch of courses for a year. The bar association, they had to get insurance with them. So they're under the scrutiny of the bar. That lasted about 5 or 8 years, and then they pulled it. But they let the people who were grandfathered in still do it. But every single one of them I ever came across or seen people, I'm helping a woman right now, and the opposing dad, he has a triple LT, and their paperwork looks stupid. It's ridiculous. Anyway, I think I got some comments or questions already, but Ron Parker is pretty good too. Who's Ron Parker? What state is he in? Eddie Nava says, I'll help anyone in the Los Angeles area. Do you have your own case going on, or are you working with other people? Let me know so I can put that put that stuff out here if it doesn't stay in the comments, or how people can get a hold of you. I guess the comments stay up here and people can look at them if they want. So if you're in the Los Angeles area, Eddie Nava's doing his own case. So, I always tell people, I can't possibly know everything. I know how the war is fought. I know how, you ever see what's the dude's name? There's this bald Grecian guy who was adopted, who does a reality TV show, and he goes and fixes up businesses. I'm forgetting the name. I think he's Greek. What's his name? He goes and fixes up businesses. He'll go down and he'll analyze the numbers, do all this other stuff, go in and fix a business that's falling apart, chew out the managers who are abusing their good workers. And anyway, he can go into any business and go in there and analyze it and look at it, and then he'll go and learn about the business. He'll go and serve ice cream right there. He'll go and clean something up, or when they tear down some walls, he'll get in there and do that. And but he could do it with any type of business anywhere in the country. So I'm kind of like that to a point. I know the warfare tactics. I know how to get on the offensive, the war of attrition. And I know some of the laws off the top of my head in some states, but it's all pretty much the same thing. And everything is under Troxel versus Granville, the United States Supreme Court case. So, trying to make sure my phone isn't getting too hot here. So, but I will never say you can't get any help or information from somebody. I could find anything anybody needs in any city in the country. But some of the stuff I have to do a lot of digging. And if you go to the family court facilitator's office, they might give you a shortcut in 5 seconds because they know that particular courthouse like the back of their hand. Now, when you do that, you want to make sure that they show you the rule or the law behind what they're doing, so you're not just saying, oh, the facilitator told me. You always want to ask the question, where do you get that from? You're telling me I can't do that, or I can't do this, or if I'm going to file a motion, I have to do it like this or that. Okay, where do you get that from? Where's the rule for that? Or if there's a law or a code, show that to me. But I'll never say I know everything. I know everything in every state and better than anybody else. I'm probably the number one advocate out here talking to people and teaching them and supporting them and encouraging them to do this stuff. But I don't know everything. I could find anything. And that's really what lawyers are. Lawyers don't know everything either, but they know how to go look stuff up, and it's whether they're willing to do that or not. That's really the issue. So, I'm going to go back up in this order. James, how did you get your exhibits about fatherlessness and abusive restraining orders admitted in your case? I bought them, including them as a motion for judicial notice, but they were denied. So, in some states or counties, like here, it's kind of straightforward. We have local civil rules that talk about when you file a motion, file this. Any exhibits attached to your motion doesn't count toward the page count or page limit on declarations. Like, let's say you can only do 20 pages for a motion/declaration. So you have a motion that's 10 pages. You have 5 witnesses writing a 2-page declaration. You're maxed out. But then it says that a financial affidavit, exhibits, and other stuff do not count toward the page count. So they assume that you can have exhibits and have as much as you want. If you go to a courthouse and they deny it, they better give you a reason why they denied it. So if they didn't give you a reason and they just said, I'm not going to look at that, then they're preventing you from presenting evidence that shows what's best for the child. And this is the phrase that you got to remember. The judge has a duty of care or an automatic responsibility. Duty of care is a phrase like if somebody's working construction on a road, they have a duty of care to put cones out a mile down the road so you don't swerve and hit them or an accident isn't caused. There's a better example is a grocery store when they mop the floor. They have a duty of care to the public to post a sign that says wet floor. Now, there's no crime with not doing that, but they have a duty of care, which is a basic human, conscience, moral responsibility to do that. So, and it's like an inherent automatic. The judge has a duty of care to look into the welfare of the child and find out what's best for the kids. As a result, they have a duty of care to look at all the evidence. So you got evidence that this is dangerous to a kid, or that's good for a kid, or that's bad for a kid, or this parent is bad, and you got text messages from them saying, I'm going to kill you, I beat the kids, ha ha ha, the court doesn't care, I'll get away with it, I'm a woman. They have a duty of care to look at that. Now, if they didn't look at it because that stuff is, scientific evidence, and the experts or the psychologists aren't there to testify, that's where you need to know the evidence rules. This is why I tell people in videos, you have to know everything. So if you submit something in court and you don't know the rules of evidence, they can throw something out because you violated it. Or they'll throw it out and it's really admissible, but you don't know the rules of evidence, how to argue to keep that stuff in. So every state has rules of evidence, and it's usually in the ER 900s that says what kind of things are automatically authenticated. If you go in there and you present the mother's diary, you have to authenticate that it's her diary. So you got a question on the stand. Do you recognize this? What is it? Oh, it's my diary. Your Honor, I motion the court to have that admitted. I move for admission. You can't testify to that diary's veracity or authenticity or what it is because you're not the person who wrote it. The personal knowledge rule says everybody can only testify to stuff that they have personal knowledge of. Technically, you can't testify to text messages and emails from the other side because you weren't with them when they texted you. But if they admit that's my email or they admit that's my phone number, then you got overwhelming evidence, and all you need is preponderance evidence that this is what it is. So then you can start testifying to it. But you got to get stuff authenticated by the person who created it. Now, the exception is self-authentication. I think it's ER 902 or 903. ER 904, 902 or 903. But you should be reading all the rules of evidence or getting my rule of evidence video if it's confusing and you can't fully understand it. And it's almost 8 o'clock at night. This is my first meal of the day, so I'm going to be rude and eat in front of you guys. But you're about to get information you won't get from an attorney who's $400 an hour or so. So the authentication rules say, and I've seen this happen before, people use scientific studies and scientific data and all this other stuff, and the judges won't allow it because they're like, that's hearsay because you're saying what somebody else said. No, I'm not. This report is automatically authenticated because ER 902 or 903, whatever number it is, says that a newspaper, a published newspaper or a published article of a magazine publish things that are in the Library of Congress or that have a government seal on it, those things are automatically authenticated. Now, if you wonder why, it's probably because you can find a newspaper article, magazine article, Time magazine, New York Times, and on microfiche in a library somewhere. But now even more so, you can find it online. And there's an official citation for any article or paper. Now, something from the APA Journal or American Medical Association Journal or Psychology Today, if it's a journal, that's even more hardcore of an authenticated thing because it's a peer-reviewed scholarly paper that's in a journal that gets reviewed by people. That's even more hardcore because anybody can write an article in Time magazine. You know, the media is all paid and bought for. Like Big Pharma pays the media to report that drugs are not dangerous, that are dangerous. And then there's some of that politicking going on with journals and stuff. But it's assumed like 4 or 5 scientists reviewed this paper and it's published. So it's hardcore authentic. Now, the other thing is a judge will throw something out that's written by a psychologist who did a peer-reviewed study and wrote a scholarly paper on it. If that judge is saying, I'm going to dismiss that, what does that judge do most of the time? A lot of the time, the judge will grant custody of father because of a presumption that the infant or younger child needs the mother more, or needs to be around the breastfeeder more, or needs to be, or, you know, it's assumed that a guy who's acting angry in court must be a domestic violence perpetrator. Where do they get that from? They get it from other people who have said so through hearsay. They're such freaking hypocrites. They go to a judicial seminar and a judge says, only 2% of cases have false allegations of false rape, false whatever. I had a guy went in front of a judge and he said the mother's falsely accusing me of molesting the kids. And that happens all the time. Then the judge testified. There's a fine line between the judge making a ruling on the evidence and actually testifying. The judge testified, maybe it's 4%. False allegations only happen 4% of the time in court. We did a reconsideration and he had another hearing. He said, you said false allegations. First of all, you testified. Second of all, you got that from a judicial seminar that you went to, so that's hearsay bullcrap. You guys are spinning that out. Now think about how stupid that is. Only 4% of the time are there false allegations. That's been the same statistic for about 20 years. Nancy Grace said it in the Duke lacrosse case when Duke lacrosse players were falsely accused of raping a stripper. Their life was ruined because they were prosecuted, in jail, lost their scholarships, can't get their life back. That lady actually just testified, or just admitted 25 years later that she was lying. The prosecutor knew she was mentally ill. The rape kit showed no signs of rape. The kids sound like a bunch of arrogant pricks, but that doesn't mean they raped somebody. You know, yuppie lacrosse kids at Duke thinking they can get away with whatever. You know, if you're a student athlete and you're hiring strippers, you go to parties and stuff, you're kind of stupid because you shouldn't even look like you're doing anything wrong or hanging with the wrong people. But my point is, Nancy Grace was saying back then only 4% of rape allegations are false. We got somebody with their lights all up in my face. I'll see if they'll turn them off in a second or else I'll move. Guess I'm going to have to move away from this retarded person because that's probably kind of annoying. So she said rape allegations only happen. Oh, now he wants to turn them off. Only happen 4% of the time. That's been the statistic all along. And judges will go with that. Why? Because they heard it at a judicial seminar, which was probably paid for by Violence Against Women Act money, VAWA money. And I just did a video on the Violence Against Women Act. Taylor Swift was up talking about it. She was talking some political crap, but she threw that in there. And this person didn't even want to renew the Violence Against Women Act, which is to protect women and children, which is utter bullcrap. So, that being said, that's an example of a judge just trusting the data that's out there by hearsay. But they won't trust data in a scholarly paper. See, this is how you got to come across with it. So to answer that question, I would do a reconsideration and talk about all that stuff. You just threw that out. When all the time you're making decisions about breastfeeding or the tender years doctrine or women telling the truth about domestic violence because of some rumor you heard at a judicial seminar, and you're not even looking at a scholarly paper or data. We're supposed to find out you're supposed to do what's in the best interest of the children, and this is key also. I tell a judge, you're supposed to do what's in the best interest of children. How do we know what's best for kids? Well, that's a matter of opinion. The best people to get an opinion from are expert witnesses like psychologists, which you guys trust all the time. Here's the overwhelming data and science about that. There is no contrary study out there. It's so prevalent that we know this, that it's become a societal norm where everybody says, dads, where are you? Crying out for dads to step to the plate. Dads to be involved in kids' lives. Because it's an uncontested fact. And why would you deny or throw out evidence that helps support what's best for a child unless you're bigoted or biased, or if you're a person of color or racist against me as a father? The courts in America have some horrific history. I just saw, man, this guy is good. I liked him before. He has a show on Fox. I liked him before Fox. So if you guys get mad because he's on Fox and you're, right-wing zealot, shut the F up with that bull crap. I look at stuff on a case-by-case basis. I just flipped between two different news channels and saw two different interesting things. But Mark Levin, he was talking about how we don't just stick with what judges say in our country automatically all the time because there's Plessy versus Ferguson. Separate but equal is equal. We had to wait until 60 years later, Brown versus Board of Education, for black people to go to the same place as white people. It took 60 years. So you could tell this court, and then there was a judicial decision that allowed Japanese citizens to be put in concentration camps during World War II, and he pointed that out. I didn't know there was a judicial decision about it. I thought the president just did that on his own during World War II. Every time there's a crisis, a war, for the sake of the children, all this other stuff, people use all these excuses to violate our constitutional rights. Hitler used the children, do this for the children, to bamboozle everybody. You got to look at the Constitution for what it is. And so you could go in there and say, Judge, the court systems in America have a horrific history of denying people their rights and treating them unequal. Jim Crow laws, the way we treated Native Americans, the Tuskegee experiment, interning Japanese citizens into concentration camps. Those were judicial decisions. You guys get stuff wrong all the time. And I'm telling you right now, this culture of anti-father, radical feminism that has infiltrated the court. Now, there's nothing wrong with feminism and equality. Modern feminism is out of control, but feminism as far as equality and being treated right, there's nothing wrong with that. You can say there's nothing wrong with feminism, but there's a fringe group of radical feminists who want to eliminate fathers. It's been well documented. If you go on my flow page and download that or click on that 400-page PDF, The Case for Father Custody, Daniel Amnius wrote a bunch of quotes in there about feminists in the early 1900s. They say we want to eliminate fathers, we want to eliminate the traditional male-led family, and basically push them out and get their money. I tell the judge, you guys have a history of that needs to stop, and you need to fix this right now. Let me make sure this isn't blurry. Yeah, I guess it's about the same. So anyway, hopefully that answers that. That's a long-winded question or answer, but I gave a few different lessons in there about the rules of evidence and how to talk to a judge and the science and all that stuff. How did you get them admitted into evidence in your case? So I just attached them on a motion. I just said, you write, let's say this is a motion. You flip it open. It's 12 pages. And then in the motion, I say, look at Exhibit 1, Exhibit 2, Exhibit 3. Here's Exhibit 1. Let's say the one about the brain and cognitive functioning. Here's Exhibit 2. All these pictures with, the best interest of the child and the fatherhood initiative stuff that has all those different pictures. I put those pictures on 4 up on one page, and in the bottom corner of each picture it says the source, and usually those are journal articles also. So, and I'm going to write in there, this is the undisputed, uncontested science, modern science of the day about children's best interest. If you take a father out of the home, automatic danger. You are severely endangering them if you make me less than 50-50. And then I would do a motion for reconsideration and put that stuff back in and say, you defied the best interest of children. You didn't even want to look into it. You don't even want to hear the science. You're a science denier, you tinfoil hat wearing idiot. Those of us who didn't get the vax or didn't believe all the COVID bullshit, when it's funny because I used to walk around. I could have been an a-hole about it, walk into stores without a mask and dare them to do something about it. But what I did was I made a mockery of them. I got one of those bandanas, the thin handkerchief with the paisleys. I had this black bandana I would wear, and I'd walk in because it was winter when the COVID shutdowns happened. It was cold up here. So I had a ski mask or a hood. I had a hoodie. I'd go into the hoodie sweatshirt. Maybe they had that over. Then I have a beanie or a ski, a knit ski hat. And then that thing over my mouth. If I would have done that before COVID, they would have called the cops because I look like I'm about to rob the place. And those handkerchiefs are so thin that stuff just comes right through. But they were cool with that as long as I did that. Anyway, I would tell the judge, you are a science denier. I would do a motion for reconsideration, and the title of the let's see if I have a piece. I had some court papers in here the other day. At the top of your court papers is the caption, James versus Sedaris Wright. At the top of the page, in the Superior Court of Washington, in and for the County of King. And then there's those 2 boxes, James versus Sedaris Wright. And then over here is my case number, and then motion for reconsideration under the title of the document. Motion for reconsideration under the title. I'm going to say motion for reconsideration for science denying treasonous judge to look at the law and look at the science and do his duty of care to look out for the safety and well-being of the child and fix bigotry and sexism. Or recuse yourself. When I do a motion for reconsideration, they're usually not going to read it. They're just going to deny it. So I want to provoke them to read my stuff by saying something provocative in the title. Ron Park on YouTube is called Fix Family Court. I haven't seen that yet. Is he trying to fix the system, or does he help people? I'm in New York. If you're in New York and you're responding to when I was talking about that guy in New Jersey, you can go to Dad dadsamerica.org. And then there's the guy in New Jersey, and his last name is Eden, as in like the Garden of Eden. And he has a phone number that's not his phone number anymore, but there's an email there that might still be a working email, because I got a hold of him one time, and I think that's how I did it, through that email. And he wrote me back and said he had a different number. So if that's why you're saying that. Okay, Javier says, if the mom requests an order to move away with the kids while the divorce is still pending and no final judgment has been made, should I file an injunction to stop her request? Hell yeah! Do you want your kid to move away from you? That's going to sever the relationship, and you're screwed if they let her move. I mean, a lot of this is common sense and following your conscience. Do I want my kids to live 1,000 miles away from me so I can barely see them? No, so object to it. I have a whole video on my YouTube channel about when the mother moves away or wants to move away. I'll talk about that for a second here. Because it's accepted as a norm and allowed. Now, Oregon is cool because Oregon assumes that a move away is bad for kids and the moving parent has to prove that it's good. In Washington and California, there's an assumption that the parent knows what they're doing and they're doing what's best for their kids. And so you have to prove that it's bad, which is a presumption against you, which kind of screws you. My baby's mom even tried an objection to relocation against me. I moved from Seattle to Tacoma. That's 30 miles away. It's kind of like St. Paul in Minnesota, St. Paul in Minneapolis, or, you know, cities adjunct to each other in New York. There's about 20 miles that separate Seattle and Tacoma. The mother objected to relocation solely because she didn't have to prove a change of circumstance and modify, and she regretted the parenting plan. And then she dropped the thing a year and a half later after dragging me in court because her pimp attorney had her on a leash, and she gave him a carte blanche. He did whatever he wanted to. Now that guy, my baby's mom's attorney, Donald Wayne Farrell, lives at Northeast 96th Street off of Lake City Way in Seattle, Washington. He used to lose cases on purpose for women clients. Some of you have heard this. He would lose a case on purpose. He would file a motion hearing, not show up or not file the paperwork, lose the case, say, oh, you poor little thing, I'm sorry. You shouldn't have gotten screwed. And she's broke. And he goes, you know what? You can live with me. I have a split level home. You can have the whole downstairs to yourself and live with me for a while. Then he would say, if you want to work off your bill and not pay me, then you can do secretary work for me. So he had a slave labor operation going on. That's just the tip of the iceberg what was wrong with that guy. A lot of you guys say, oh, you've never seen an attorney like mine. You've never seen an attorney like the one I dealt with. And I beat him in the Court of Appeals twice, and he hates my guts. So he started working for free the last few years because he made it his life's mission. And it was his greatest sexual arousal desire to hunt me down. And I've been at his house a couple times protesting. I passed out flyers or mailed flyers to his neighbors talking about what a monster he was to let everybody know, like we would a sex offender or whatever. But back to the relocation. The number one basic parenting 101 thing that you need to have, the number one quality that you need to have as a parent is unselfishness. If you're not unselfish, your kid will die because you won't think of to feed the kid, look out for the kid, put the kid first. You have to put your child's needs above your own sleep sometimes. You have to wake up in the middle of the night. Child has a fever. Take him to the ER. Clean up, throw up. Put them back to sleep or whatever. I used to have to drive my daughter around because she would, oh my God, my daughter would get tired and her tiredness would annoy herself. She would be annoyed by her feeling of tiredness, and that would make her cry, and her own crying kept her awake. It was a vicious cycle. So I would have to get her up and put her in the car seat and drive around, and then she'd fall asleep. And hopefully, when she woke up, when I took her back in the house, it was only momentarily so I could put her to sleep. So you have to do stuff like that. You have to be unselfish. So your baby's mom created a child with you. Your life should revolve around your child, at least for the early years. If your life doesn't revolve around your kid in the early years, you're a neglectful, unfit parent. Now, when somebody moves, why are they moving? You need to be doing discovery on that. A deposition, ideally. If you have an attorney and an attorney's not doing a deposition the day after the mother files a request to move, your attorney's a stupid jackass. Your attorney's got to be out of their damn mind. And if you don't know that, you know it now. Why are you relocating? Oh, I have a support network in San Francisco. Well, we live in New York. I'm the support network. Why are you shitting on me as a father? I am the other support network. Why do you need other people? Why can't you be like a million other single moms out here and raise the kid on your own? But you're not on your own because here I am. The fact that you shit on me and pretend I don't even exist and you need a support network is either a pathetic excuse, a lie, or a delusional thing that says I can't do it myself, or it's an admission that you're unfit. You need mommy and daddy. The umbilical cord is still there. I saw the first relocation case that I saw in Washington when the relocation law was created in 2000. This guy worked at Microsoft, and I feel bad for him because he was coaching his kid's baseball team and doing all this other stuff, and he probably did it. Maybe he did it because they had a coach-player relationship, or maybe he did it to be involved in the kid's activities, and that's always a good idea. If you want to be around your kid and your kid plays sports, be a volunteer manager or coach. You get to be around him a lot more if you're a non-custodial parent. Anyway, the mother was allowed to move to Louisiana from Seattle because she was homesick. Now, ain't that some punk-ass bullshit? Homesick? So the child's basic life need for a father is trumped by the bitch-ass mom's emotional trauma from being homesick. You moved to Seattle away from Louisiana to get away from your family and start a new life. Now you need to go back to mommy and daddy? You're a grown-ass woman. You need to go back to mommy and daddy? There's 10 million other single mothers out there who are 100 times more fit of a parent. Go ahead and move. I'll take care of the children. But the thing is, that's selfish. I want the convenience of people around me. I want the convenience of going back. I want to move the child. I want to move. I know a dad in California, his baby's mom became a lesbian and moved to Georgia because her partner, lesbian lover, I think they got married. So her wife had a career down there. So they were taking the child away from the father because of the lesbian lover wife's career. And they said, well, it has a big backyard and all this other stuff. And the dad, I don't know if he did it. I told him, when you go to trial, say, so this lady is saying grass and a big yard and fence are more important than love and affection. You can't be a normal human and actually think that. Only a subhuman piece of shit, dumbass, airhead, retarded idiot would say this kid needs a big yard in Georgia more than the father in California. She's selfish. She's narcissistically selfish and mentally ill. And I know that it's the norm to just let mothers relocate, but that's because we had an anti-father bigotry for the past 60 years in this country that wasn't recognized until now. We used to have the tender years doctrine. Some states have eliminated that. We used to have a bigoted sense toward fatherhood because we were bigots, just like we were bigots against black people or Native Americans or Asians. And it was the public policy of judges and courts to be bigoted. Now, the biggest bigotry we have in this country that's prevalent and goes state to state, and it's actually it's in Canada, Australia, and Europe. We have this bigotry that's prevalent and ubiquitous everywhere, and it's no different. It's this bigotry against fathers. The culture of the court has allowed us to have the tender years doctrine for a while. What did the tender years doctrine say? That children are presumed to be better off with the mother in the tender years. That's from old Europe, 1860. Our modern science, modern day technology, our court system that lives in this modern day technology we have, we were so dumb and bigoted that we went back to 1860 in Europe. A doctrine that was created to rescue kids from absent mothers because fathers always got custody in old Europe. And fathers would have custody and the mothers would barely see their kids. So the pendulum swung the other way over there. Let's see if that's better. No. The pendulum swung the other way over there. And went from fathers always having custody, the mothers always having custody, and fathers didn't see their kids for 5 or 7 years at all. It was insane. And we followed that tender years doctrine. I would be taking the time to educate the courts on this stuff, but you got to educate yourself on it. The basic fundamental characteristic of a mother, unselfishness, is not there because she says, oh, I need to move because I found another lover on Match.com and my romantic life is more important than the kid's basic life needs. See, when you break down what somebody's actually doing, you can actually make them look so stupid that you say, Your Honor, don't be part of this radical feminist extreme agenda that says, oh, we could just crap on fathers and make them every other weekend visitors. We could just be selfishly narcissistic and take kids away because it's my feelings and it's about me, me, me. When you have a child, your life needs to revolve around the child. I'm making my life revolve around the child. The mother is like, I want to go do this, I want to go do this with my life, and the child has to tag along. She created a child that has no sense of a normal, fit, reasonable mother who says, my child comes first. My child needs a father more than any. Name one thing out there in San Francisco that's more important than me. Name one. You can't. And see, nobody asks these questions. That's why I yell in my videos like I'm yelling right now, because everybody's so freaking stupid and such a bunch of pussies that you won't go in there and tell this truth that needs to be told. That would be like somebody going into Jim Crow South and say, I know you guys all think that black people are subhuman animals and evolved from apes and stuff like that, but I really would like you to consider this one guy who's kind of smart. That's not a good way to undo their psychotic, evil, demonic racism. You go in there and say, how dare you think that this person is subhuman? All the science and all this says this and that. And black people are intellectual because of this example and that example. And you end up making them look stupid. You know, in Jim Crow South, that's what Hitler was. Hitler was a eugenist. He wanted to eliminate the Jews, and he wanted to eliminate people that were not like him. You have the same megalomaniac, narcissistic ego problem. You know, that's what they should say in Jim Crow South when they're pointing out how stupid they are. But they have all their buddies, and everybody else is in the Klan, so nobody cares until you start convicting them in their soul or in their spirit and changing their minds. But nobody wants to go in and say the stuff that will change their minds. It's so insane because a lot of you guys won't do stuff because your attorney says, don't do that. Why not? Oh, because we just don't do that around here. We don't go in there and tell the truth. We don't go in there and demonize the demon. We don't go in there and talk about how much of a monster the monster is. Then what the F are you doing? Oh, we're just going to go in there and pretend that the mother's not a drug addict with a pedophile boyfriend, a sex offender boyfriend who has 3 domestic violence criminal acts in his history. And we're going to pretend that the children aren't in a toxic home. And we're just going to hope magically you get 50-50. You see how stupid this shit is? And see, I'm the bad guy, and I'm the guy who's not going to get 1 million followers because bitch-ass con artists like Steve Maeda or Family Court Corner or Judge Anthony, or I just found that you guys see that, did you guys see that video I did on the guy in Texas? Is Penal Code 25.03. That's the code in Texas for like abducting a child. This guy looks Latino, kind of chubby. He has his dark hair parted. I think he has a mustache, if I remember, or a goatee. I posted a video. He says, if you're a pro se, you can't win. I won. That guy's lying. I don't have time to educate that guy. That guy should have figured out that there's people out there who won. But he had to go with his own personal, narcissistic, megalomaniac experience. Oh, in my world, I lost, so nobody else can win. That guy's got like 25,000 followers on Instagram. I have to start over. I had 2,000 followers and my first one got deleted. I might have like 10 or 15,000 by now. I had 13,000 followers on TikTok. On my first TikTok, it blew up really fast when I did a couple of videos. Then it kind of evened out. And now I'm on my 4th or 5th TikTok now. I probably have 25,000 followers. But I'll never get that million followers because that's the people being nice and saying, oh, here's some fancy schmancy legal terminology. Follow me. Or I could be a bitch-ass, whining, crying little crybaby and post a bunch of memes. Family court alienates fathers. Dads are people too. If you're a dad, you're getting ripped off, and child support should be reformed, and family court should be reformed. You know how many millions of mother effers have been saying that for 60 years? And they're not doing anything? There's this guy. He has a page, Fathers Are Important, on Instagram. When I had first seen him about 4 or 5 years ago, he had asked me to come on and do an IG live or a podcast with him. And we set up a time. I got up early because he's on the East Coast, and he was a no-show. That mother effer didn't even give me the courtesy. He reached out to me again. He said, what do you think about this and that? DM me. I said, dude, stop wasting my time. I got up early for you, and you bailed on me, and you were a total flake. Oh, sorry. And you know what that guy does? He takes other people's videos that they manufactured and made and reposts them on his page. He's got like 80,000, 88,000, 90,000 people following him. I could do that, but that's some bitch-ass shit. I'm going to go and steal somebody else's videos that they work hard to put together, and I'm going to repost them just so I can get views. What answers are you feeding people or giving people? There's this guy, his page says, who's the deadbeat? D-A instead of the. Who's the deadbeat? On Instagram. I was telling him how men need to go for full custody, always shoot high, at least for that goal, and just men should have custody, period. He goes, well, each case is different, and guys shouldn't always do that, and 50-50, and blah, blah, blah. I said, don't give me that bitch-ass, stupid-ass shit. Women are going for the throat, and you're sitting here saying, play nice. And he's like, you don't know what you're talking about. I'm like, I've been around. I've probably been around longer than whatever your age is. I just saw that guy bragging about how he got custody. These mother effing father's rights pretender bitch-ass idiots who can't think. I take it very seriously when I tell you guys stuff. Like, I don't say stuff flippantly, like stuff that's my feelings or my opinion. My case is over. I got full custody of my daughter. She's 23 now. I raised her. So I did it all. So, and I'm obviously not here just to be Mr. Popular, or else I would have done it politically correct, and I'd have 100,000 followers right now. So I'm out here telling the truth. The truth tellers are not always the famous ones, especially right away. The truth tellers during COVID got shut out. The truth tellers when it comes to politics, they get shut out because the media is bought by different groups of people. Right now, you see, here's a great example. RFK, he's a lifelong Democrat. His whole family's a bunch of Democrats. They loved him when he was a Democrat. He feels rejected by the Democratic Party, so he hopped to another party. His campaign to make America healthy, you know, the health secretary they had before that is this fat, ugly, nasty pile of Jabba the Hutt looking tranny goo. And JFK is buff and ripped. And they weren't mad about the guy who was appointed there. Forget who was president. Look at the intrinsically what it is. And so now people are hating on him, but the people who are hating on him get millions of big pharma money. Bernie Sanders was saying, are you going to say you're against all vaccines and stuff like that? And RFK said at this hearing, you took millions of dollars of vaccine money or big pharma money. He goes, no, I didn't. Not from one CO or one PAC. He left out the top notch, but he took millions of dollars from all the middle management people that worked in big pharma. Nobody caught that part. Everybody is a fake, phony mother effer in this world. I'm not here to get my rocks off on having 1 million followers, 1 million likes. I'm here to tell the truth. You don't like it? Go somewhere else and continue to lose on your case. That's my stance. You would think I would have millions of followers because everybody's like, where's all the truth in the world? Where's all the loyalty in the world? People are so flaky, or people are so, Judas and betrayal. And here I come with the absolute truth, and nobody likes it because it hurts their little sissy-ass pussy feelings. War is hell. Family court is war. Family court is hell. You have to fight like hell to give yourself a chance to get something fair. You don't like that? Get the F out of here. And 99% of dads don't like that. And fathers' rights movements are a bunch of pussy-ass bitches waiting on the laws to change. You know how long they've been waiting on the laws to change? 60 years. They've been crying about it big time on social media since social media started. What changes have they made? None. There's 5 states that have 50-50 laws. Missouri has a 50-50 law. They care so much about kids that they say there's a presumption of 50-50. Unless there's abuse or child abuse or domestic violence, which that's how women get custody anyway. So women are going to get custody. They're going to make those claims even more often. So you can take away a father's rights and the 50-50 is out the window. But Missouri is crazy because if you read into the second or third paragraph in that, and these mother effers didn't even read this shit. It says there's a clause there, if the judge doesn't think it's the best interest of the child to do 50-50, he doesn't have to. So we're right back at square one. What's the whole point of the law if it sounds like the previous law? This is how stupid my gender is. It's like walking around the Matrix and you're trying to wake people up and everybody's falling asleep, or any movie that you've seen where people are ignorant and they're walking around and somebody's trying to say, hey, the government's coming after us. Big Brother's coming after us. Or the Matrix. Or Paul Revere. The British are coming. Everybody's like sleeping. Like, shut up, dude. Go to bed. You're disturbing us. We don't like the inconvenience of you saying somebody's trying to come kill us. So, anyway, the question was relocation. And so, women, I would go and say, this woman is such a mentally ill, selfish narcissist that she doesn't even think for a second about how well the kids are going to do or badly they're going to do without a father. All the science is in my favor and all this other stuff. When you're a parent, the number one characteristic you need is unselfishness. She wants to put her life, her convenience, her dating relationship, her family, whatever first. She says she needs a support group. I am the support group. There is nothing you can cite one thing, Your Honor, that's more important in San Francisco than me. Greater than, less than. Remember third grade, Your Honor? 5 is greater than 3. Cite one thing that's greater than the need for a father. The mother wants to take half of the child's needs out. What if she decided, I'm just going to give the kids water for the rest of their lives and not food? Or they can have food once a month. That's the best I can do to get out to San Francisco. How insane is that? But see, you got to say this brand new stuff that nobody has ever said. For 60 years, punk-ass bitches have been whining and crying about the family court system, and nothing has changed. I got full custody because I got in there and went on the fence. I said, the mother's living in a cult-like home. Her and her sisters hate me, and they hate me so much they don't want the child to have a father. They have a wicked, bitter hatred toward me. I don't care that she doesn't like me. She can hate my guts if she wants to, but she can't hate me so much that she hates the child and deprives the child of a father. I said stuff like that in court, and attorneys would tell me not to do that. Goldberg and Jones, I have a video on them on my YouTube channel, on my playlist. There's a playlist that talks about corrupt judges and attorneys and GALs, etc. I did a video on my own guardian ad litem. I threw my baby's mom's attorney in a couple of my videos there. I did a video on David Contos in Kent, Washington, who was having sex at the courthouse when he was a pro tem substitute family law commissioner or judge. And him trading sex for services. I need to email that to the courthouse and let them all know about that. This is the type of stuff that you got to wake them up with the chain. Everybody thinks, hey, let's walk around like a bunch of pussies and hold a sign outside the courthouse once every 5 months, and then the entire system will change. That's like us going into Iraq and fighting the Iraq war. We went in with shock and awe and bombed the shit out of them. Now, the whole war was bullcrap, but you go in for a war, you go in with shock and awe, you're going to have them running scared. You go in with a little pop gun and say, oh, I'm going to get you. I'm going to get you. That's not how you go into a war. It's insane how everybody just tolerates shit. And I just saw a study where they talk about 97% of people don't want to ruffle any feathers in life or do anything and just want to blend in the crowd and basically be a sheep and get along. And then everybody's whining and crying and pissing about the system, but nobody wants to do anything about it. You have to go in and unbrainwash them and say something different than what everybody else has said. My husband is ordered to pay child support and the mother is given residential custody. The child doesn't... Oh my God. I parked in the wrong spot. Okay. Sorry about that. My husband is ordered to pay child support. The mother has residential custody. The child doesn't live with the mother, and they keep denying him enforcement. I feel like it's illegal as F. Have him go get full custody. What is he waiting on? If the child doesn't live with the mother's not performing parenting duties, and depending on what state you're in, most states say, here's the factors for determining custody. This is where, if he has an attorney, the attorney's a total dumbass, because the attorney's just got to read the law. In Washington, it's a huge thing. If you don't perform parenting functions or parenting duties, if you neglect to do it, or if you refuse to do it, that's a mandatory basis to take kids away. But this also should be common sense in every other state. The parent is getting child support and the child doesn't live with her? Somebody else is doing the parenting? How does anybody else other than her have rights to the kid? Give me custody. I will take care of the kid. They have no legal rights. She's abandoning the kid. She's neglecting the kid. I should have custody. The end. Have him go get custody. It's perfectly legal for her to get child support when she's the custodial parent. Your husband should not be worrying about child support as much as if the child is with somebody other than the parents. If the child's with somebody other than the parents, what are they doing there? That doesn't make any sense. It shouldn't be the child support is illegal. Your husband should be getting off his ass and going for custody of the kid. That's not a deep legal, scholarly thing. That's common sense. The mother's abandoned the care to somebody else. He should have the kid. But there's laws about that. Whatever, look at the laws in your state. Go if you live in South Dakota, best interest of children. Custody factors. And then there'll be, anywhere, depending on what state, there might be 5, there might be 15, there might be 20. And at least one of them is going to be about who performing parenting functions and parenting duties and parenting responsibilities. I've been working with fathers for about 3 years. It's my opinion that the most successful litigants correlated with a deep philosophical overhaul in their lives. I don't know what that means. A lot of crybaby. Oh, okay. A lot of crybaby dads only want 0 child support, 50-50 custody, power and control. But they also don't want to make some very important changes to demonstrate maturity and growth. Almost every dad I deal with wants 50-50 or equality. So I'm not sure about all that. But if a dad doesn't want to pay child support, that's reasonable to me because child support's an unconstitutional scam. Just like we shouldn't want to pay income tax because income tax, there's no law that requires you to pay an income tax. The tax code The tax code says that this is voluntary compliance. They want a bunch of IRS employees that once they looked at it, they left. They got together and put an ad in the USA Today in the 90s and said $50,000 reward if you show us the law that says you have to pay an income tax. And nobody won the reward, and there's no law on it. So guys not wanting, now supporting your kids voluntarily, when my baby's mom was pregnant, I was giving her a few hundred a month, 300, 500 a month. I took a second job because I wanted to make sure everything was cool. That was when we got along. Most dads, I find, are generous with child support and they overdo it. So I don't know all the dads you're dealing with. I've dealt with 25,000 cases, and the vast majority of dads pay child support. They overdo it. I tell them to stop giving money to their baby's mom because they're just empowering her while she's withholding the children. So I don't know. Dad should always go for full custody. This 50-50 bullcrap. If you're dealing with an alienating parent, you're never going to be able to get along. You're never going to be able to co-parent. You're going to be fighting all the time. So the peaceful person should be in control. If the mother wants more time, you can let her have more time at your discretion. Can I file a complaint about the judge being biased? Of course you can. You need to look up case law on that. A judge being biased is grounds for them to automatically recuse themselves. If you're Peruvian, is that what you say if you're from Peru? If you're from Peru and the judge hates people from Peru, he should step down and say that I'm biased. I need to step down. I hate people from Peru. And then, if a judge merely appears to be biased and they're not biased, that's a mandatory basis for recuse also, because the courts have such a strong presumption of fairness and equity that judges can't be biased. Read the Code of Judicial Conduct. Read case law on bias. If you don't know how to look up case law, you probably should get a consult with me. I probably should make a packet that people can get in my store, because I got motions and legal memos about recusing judges and their bias. Just want to say thanks for your brutal honesty and valuable perspective. Thanks. Thank you. What is it called on your flow page? What is the called on your flow page, Eddie? What is what called on my flow page? If you're asking where my flow page is, go under every video, every YouTube video, there's a link to my flow page. If you're talking about what do I have on there, there's a link to my store. There should be a link to my store under every video also. There's a link to my store. There's links with free pamphlets I have on how I deal with mediation, cops, and CPS, and how I deal with a lawyer. I have it written out. It's some pamphlets I did a long time ago. I found them again, so I put them up there. Links to interrogatory sample, all the science and all the data. But everybody should go to my flow page and look at the section that says must see information. I call it must see information because every dad must see that stuff. Or go out and do your own research and find something similar. And then I have my winning court orders so people can see proof that I know what I'm talking about. It's all gravy says we are the victims. Yeah, we are, but what are we going to do about it? Sit around and pout about being victims? That's what the Father's Rights Movement bitches do. I'm not saying you're saying that, but yeah, we already know we're the victims. So what are we going to do? If people are in prison and are captured by the enemy, or somebody gets violated, they can sit around and say, wow, I'm violated. I can't believe somebody stole my stuff, or my kid is missing, or I'm a prisoner of war. I'm in prison. Like you got to do something about it. If you want to succeed, you really have to begin to look inward and make a dedicated commitment to the sacrifice of the greater good of the child. Yeah, and that's what a lot of women don't do. They think they own children and they're entitled to be paid money for them because they spit them out. In my county, we are seeing a shift towards an equal shared custody baseline, and stories of fathers winning equal custody in the courts is on the rise. I've heard that for 60 years. I don't ever believe that. I need to see some data on that. I think people hear a case here and there and they feel good about it. There's always been dads getting custody. The ratio of custodial fathers compared to custodial mothers is still 90-10. I don't see any shift in it. So I would disagree with that. Maybe you're seeing it in your particular county, but I mean, are you seeing an overwhelming change or just some dad won here and some dad won there? I'm not seeing it. I hear people say that all the time. Well, I can really feel momentum. I can just feel it in the air. I can really feel it. I see it. And I see, like I said, there's 4 states with 50-50 presumptuous laws, and dads are getting screwed left and right because there's an exception of domestic violence and child abuse. And what do women do? They claim domestic violence and child abuse to get custody now. How much more are they going to claim it in that situation? Can someone do a motion for reconsideration once the orders are finalized? Yes. The motion of reconsideration is you can reconsider any order within the deadline to do a reconsideration. A lot of states it's 10 days. Some states, I think Florida doesn't have a limit. California is 30 days. I know Washington is 10 days. You have to look up Civil Rule 59 or whatever the motion for reconsideration order is. You know, most states follow the same numbering system as the federal rules. It's usually Civil Rule 59. Motion to reconsider or motion for a new trial. But you can't just do it because you don't like the ruling. There has to be a basis in the rules. So you got to read the rule. In Washington, there's 9 reasons to do a reconsideration. Clerical error. So the judge ignored the law. Substantial justice has not been done. Stuff like that. Knowledge is power. How did you get judge's home address? It's easy. You can find anybody's home address nowadays. I think my judge, I mean, if I type his name in Seattle on the white pages, a couple addresses come up, and then I cross-referenced it with another place. We have a voter registration database that's public. I can't even remember now. There's like 4 or 5 different ways to do it. I use Intellius to look for addresses. Service that's $35 a month. My baby's mom moved from California to Iowa with her family while pregnant. And the judge scolded me in the final hearing for filing for an abduction case because there was no baby at the time. I would have told that judge, so when you have a car accident with a pregnant woman and the baby, you know, the baby is the pregnancy is terminated and the wife dies, how do you charge a double homicide? But technically, you don't have any rights until the child's born and you're on the birth certificate because there's no proof that you're the father until then. So it depends on how he said that. I would chew that guy out, though. Currently writing a motion for reconsideration per your strategy. Also writing contempt motion 2 weeks after the final order filed. Should I file both together or separately? I file motions as soon as they're needed. If somebody violated my visitation or custody rights or whatever, I'm filing it the day after it happened, just like I'm calling the police as soon as I find out my car is stolen. I don't wait. And then if somebody breaks the window to my house another day, I will call on that. Every time something happens, I will do it immediately. If there's a bad order, I'll reconsider. If there's a violation, I'll do a violation. A prosecutor, if you commit murder and then you go out and steal some bubble gum, they'll charge you for the theft of 7-Eleven bubble gum and the murder. Just do it. I mean, I don't know why you wouldn't do it separately unless there's some other legal strategy you're thinking of. I included attorney's lies in my motion to vacate the restraining order. Should I put it in a contempt motion against him and the attorney for the child? How did you do it? I've never done a motion to vacate a restraining order, so I'm not sure why you're talking about how I did it. But if some attorney lies in court papers, I cite all the rules of professional conduct they violated. I would cite Civil Rule 11. I would cite their duty of care to be honest to the court. I would call it a frivolous abuse of the process. Here's a quickie little tidbit. Somebody just pulled up right in front of me with the lights on. Okay, so in Washington State, RCW 26.51 says that abuse of the process is a form of domestic violence. I would go in there and say I'm a victim of domestic violence because she abused the process. But I would also go in there and say, maybe, I think you're the one who already got my packet, and cite all the different people, including the Bar Association in California and the Bar Association in Illinois, that both said that women lie about protection orders more than they tell the truth about them. I would go in there and tell them that. And the attorney committed a fraud upon the court. So contempt is a violation of a court order. If an attorney is lying on a protection order case, that's not violating a court order. They're just lying. And they're helping their client commit perjury. I allege all that stuff and put all that in there. I'm so glad you started doing lives on YouTube with your content. This is great. Cool. Judge Anthony, somebody's laughing at him. Family law attorneys are the dumbest people on the planet. They really are. Tips for winning an appeal. I could talk for hours about that. You have to understand that an appeal isn't, you don't get to retry the case over again. Whatever the court made a finding of fact is a fact on appeal, and you have to say the law was misapplied. So you have to make sure you attack the law. You have to know case law on every issue you're talking about. They won't listen to you if you don't have case law. So, like in my case, I went a reversal in the Court of Appeals because the judge didn't make the mother pay daycare and medical. We had an illegal order that said I had to pay 100%. The law says you have to split it. And the judge says, well, she doesn't want to talk to you, so I'm not going to make her pay it. Well, the law is very clear. So I said he violated law. And then I found case law where they reversed people in other cases when they didn't make the dad or usually it's a non-custodial dad, they didn't make the dad pay daycare or medical or long distance transportation costs, which are the three basic you have to pay above and beyond child support. So I found case law that says this is wrong and people have been reversed, so it helped make an automatic ruling. A lot of people think you go to the Court of Appeals and you retry the case. If you're found to be a domestic violence perpetrator, when you go to the Court of Appeals, you're a domestic violence perpetrator. The only thing you could say is they didn't give me enough time or a step-up plan. They got to give me the right to fix my domestic violence problem and then increase my time until we get to a point of shared custody or whatever. You don't get to say, I'm not a domestic violence perpetrator and here's why. There is an exception to that, though. That's the presumption. There's an exception that says, unless there's overwhelming evidence or there's no substantial evidence to support that finding, but the findings will not be disturbed. They're called verities on appeal. Verity, veritas, Latin word meaning truth. So everything they make a finding of fact on, you make $5,000 a month because they impute your income because you used to be a construction worker and now you're working at McDonald's. You can make $5,000, so they impute it. That's a finding of fact you can't change on appeal unless you have overwhelming evidence in the file that says that that's stupid or wrong because you can't get that job or something like that. But you should assume that the facts on appeal remain the facts, and only you have to apply abuse of discretion or misuse of the law. Like, let's say you were a domestic violence perpetrator and the mother appeals because you got 50-50 custody, and the law says they have to put restrictions on you, and they didn't put restrictions. She could say he's a domestic violence perpetrator, they didn't put restrictions, they have to put restrictions. So it's an application of the law. A lot of people don't realize that. Who's going to carry the logs in the boats? David Goggins fan there. Exactly. Judge, your ex might be crazy and a liar. You married her, deal with it, or you will be seen as a weak father. My baby's mom was crazy. I was stupid to get with her. She had a side that looked good. If her sisters weren't involved, I'm convinced she wouldn't have turned out the way she did. She had allegiance to her sisters and her family. That was the problem. She even told me like a few years later, if we had our own place or some place to go, things would have been different, which means I have to listen to my mom and a narcissistic sister who hates you. If you got in-depth questions, better off getting a consultation or something. Yeah, I mean, I can't say, like the appeals, I could talk about an appeal for 2 or 3 hours depending on what your issue is. I don't know what your issue is. So there's some stuff you have to get a one-on-one consult. If you really want to learn everything that you need to know, if you really want to learn everything you need to know, you need to get a one-on-one consult. Everybody who really wants to be on top of this and know it and learn it really needs to get a good 5 hours in with me. Everybody I've seen who's mastered this stuff or knows how to do it, sometimes it might come back to me later for a tweak here and there or some dive deep on something else. Everybody who's mastered this stuff has spent 5 hours with me. That's kind of the average that I've kind of guessed if you really want to master. Now, some people sat with me one time and I hear from them a year later, oh, I got custody, I got 50-50. They just took it and ran with it and they made it their life goal. And 24/7 they were diving in, and or sometimes all they had to do was stand up to an abusive mother, and then she just wilted. So, it all depends. It's the plastics with the feminizing chems. That's part of it too. What a dumb nuance in Missouri. Yep. Straight stupid. There's nothing greater than a parent to a child. Yep. They keep overlooking it in New Jersey. He has multiple reports of interference. He's been trying to get full custody and they keep overlooking it. Well, he's got to go in there and demand and say, you need to, because New Jersey has factors like everybody else. I can't remember off the top of my head. I don't know if I have a link to New Jersey. But they have to consider certain things. And you got to go in and tell, has your husband told, I think this lady has a husband, has your husband went in and say, you have to place the child with one parent or the other who's performing parenting duties. She's not doing it, so you have to take the child away from the home. That grandma or the aunt or whoever the child's living with does not have any rights under Troxel versus Granville. You are being a treasonous hater to the Constitution and to the law and violating your oath. You got to tell the judge that stuff. I'd love to collab with you. I think I'd need to explain my opinions. Well, that's what a one-on-one. If you're lost, if you don't know everything that you need to know, watching my videos and stuff, which after you watch my videos on YouTube, it doesn't explain everything about every detail about your particular case. But you've got to, master this stuff. So, because I mean, the more you know, the better you're going to perform your case. And you want to know everything. If you don't know everything, you got to get a consult. I wrote objections to the magistrate so I can appeal. I cite law, rules, and case law they violated, but judge keeps denying with not well taken without giving me a hearing. So I got to put, that sounds like another one where I would put in the title, motion for appeal from, what'd you say it was? Magistrate. Motion to appeal from a magistrate who violated law, committed treason, and has an abuse order that abuses the children. And then right from the gate, this order is abusive toward the children. All the science says it. If you deny this or don't give me a chance to be heard, then you're a science denier. And you're violating the Code of Judicial Conduct. And you scare them that you're going to file a complaint with the Code of Judicial Conduct. This is what I'm talking about. You guys need to know everything. If you guys have done certain things and it hasn't worked and you don't know what to do next, you need to get a consult because you need to know everything and every option. There's still no guarantee because the system is corrupt, but you got to exercise every little thing that you can. But to be honest, the wins really come with the war of attrition. The more you beat the other side down, the more leverage you're going to have when it comes time to settle, and 95% of cases settle. So if you're not doing stuff outside of court also, like depositions and discovery and writing letters and wearing them down financially, which you got to have a legitimate reason. Like, you don't write letters just to write letters to drain them financially. But every time somebody sneezes wrong, I'm jumping all over it and writing a letter to the attorney. I'm filing a motion with the court. I'm doing discovery. If they're not answering discovery, I'm doing a motion to compel to make them answer. Maestro with the Commissioner for Judicial Behavior. Google it and they will tell you the process for your state. Maybe, I don't know what that is. Maybe that's the reconsideration thing. I'm filing a contempt for denying the minimum face time per week. the first week of the order, considering to use the contempt to further prove my argument in the motion for reconsideration. Yeah, if somebody can't do something as simple as FaceTime, when the family's broken, that's traumatic to the kids. The father's pushed out further, that's further trauma to the kids. That makes FaceTime more imperative to maintain that bond. This person can't even do that because they hate me more than they love the kids. They're undermining this stuff. If they can't do something as simple as that, that's like they can't feed the kids. They can't give the kids their medicine. They're not giving the kids a basic life need. And your court order says this is what's best for the child, and she's defying what's best for the child. You should hold her accountable. This is the type of way that you need to talk to the judge, and nobody is doing this. And everybody's like, oh, the system's going to change, and we just hold our breath long enough. You got to go in and do stuff different than what we've been doing. I'm down to talk again soon. What? Oops. Be cool to not just be prepping for a hearing this time. We've never done that. Can you subpoena text message? You can subpoena anything. You just got to do the subpoena process right. Texts are kind of hard, but you can do it. The attorney for the child only asked questions to the mom that made the mom look good during direct examination. The AFC has not had any interaction with me during this case. What would you do? I'd be writing letters to that person all along the way, filing a bar complaint against them if they're you said the attorney for the kids, so they're an attorney. I'd be pointing that out to the judge. I'd be doing a reconsideration after a hearing like that. I would write a letter. How come you're interrogating the mother, making her look good? Are you one of those guardian ad litem, advocate for the child types where you're bending over backwards for the mother? How come you didn't ask me questions? And see, when there's a guardian ad litem or attorney for a child, I'm writing them and keeping them in, and I'm putting stuff in writing where here's what's best for the kid. I mean, here's the problem with the mother. List the stuff, attach exhibits, and then I'm going to say, how come they're not bringing that up? I gave them a paper trail of all these problems, and they're not even attempting to bring this up. That person, and then I'll follow up and say, you didn't ask questions about, maybe follow up and write a letter saying, you didn't ask questions about this, 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 and this. How can we not concerned about the child being abused? How can we not? Oh, I get it. You are acting as the mother's attorney because you're a radical feminist, man-hating bigot. I'm going to ask you to step down, or I'm going to hold you accountable 4 different ways. And don't tell them, file the bar complaint, motion to remove them with sanctions, ask them to be sanctioned with the court, and then sue them. How do I get a different judge in Washington? My judge is biased and refuses to hold her in contempt, even when the statute and precedent is on my side. It all depends on how you argued your contempt. I mean, if you go to court and you argue and you lose, you can't really say the judge is biased because I lost. You have to have something more than that. I'm in Washington State. I know Washington like the back of my hand. I won my first attempt at contempt. I've seen judges getting dismissed. I know a lawyer that got a commissioner removed permanently because he said that she was biased. He wrote a letter to the judges that appointed her. So, I mean, if I was you, I'd get a consult with me because I got, if you're, in my flow page, there's a link to Washington's version of Lexis. Lexis is where you look up case law, or Westlaw are the 2 Mercedes-Benz BMWs of legal research. So, Lexis, there's a kind of a Mickey Mouse version of Lexis on Washington. You should go in judicial bias, and you should write a motion for the judge to recuse themselves because of their bias, and they can't even appear to be biased. And what they're doing, at the very least, appears to be biased because of this, that, and that. Now, refuse to hold her in contempt, even when the statute and precedent is on my side. So, tell me what the contempt is. Is it visitation? Is it phone calls? Is it joint decision making? Because a lot of times, if you have all the law and stuff right, where you may be going wrong is going to court and not arguing correctly. When they're doing contempt, like I just said earlier, Your Honor, your court order says this. This is how I won my contempt. I said, Your Honor, the mother's attorney is saying, oh, it was the order was confusing and it was written down wrong and I miscommunicated with my client. It's more my fault, Your Honor. I said, Your Honor, okay, visitation withholding. Okay, so I said, Your Honor, they're sitting there saying there's a miscommunication on their side. Why do we write stuff down in court orders so that everybody's on the same page and they see what the order is? I was trying to get visitation with my kid. The mother said no. The mother said in a previous hearing that she wants me to have the kid. And then when I finally get a court order, I don't get the kid. And they're saying it's a misunderstanding. She's got a lawyer and the plain language of the order is clear. What more should we be doing? We write stuff down so people follow orders. Now, also, if they're denying visitation, the court order says that's the best interest of the child. The mother's not doing the best interest of the child. You are the one who has the power in your hands to make sure the child's best interest happens. Why would you write an order that says this is what's best for the kid and say, I don't care if it's violated? That means you don't care about the kid. Why would you do that? If you write down an order saying the child needs 3 square meals a day, she needs liquid water and electrolytes and vegetables and fruit, and the mother just gives the child water all week long and starves the kid, you would be outraged at the mother. But she's starving the kid of a father right now, and we have a problem in this court system, which is well established, with anti-father bigotry, and it seems like you're giving into it, just like the judges used to give into the bigotry toward black people in Jim Crow South, or the bigotry this courthouse did during World War II when Japanese folks were interned. You have a bigotry against fathers, and it's very clear, and you need to step down because of your bigotry. Or else what's clear is that you're helping out the mother to alienate the children, which is a form of child abuse. So this is what's best for the children. It's being deprived from them. So they are being starved or neglected and they're being abused. And you're sitting there saying, I'm not going to hold somebody accountable for abuse. What kind of judge are you when you don't do that? How can you... The mother is flipping you off and flipping the court off and thumbing her nose at the court, and you're saying, man, no big deal. I don't care about the integrity of our orders. Why are you even a judge? I guess if she violates the court order on visitation, I don't have to pay child support because you're not going to find me in contempt. Oh, well, wait a minute. You'll throw me in jail if I don't pay child support. Why? Because you guys get Title 4D money, and money is more important to you than love and relationships. So this child is going to end up having emotional and psychological problems because the mother gets to alienate, and you're empowering an alienator. You are empowering child abuse. Knock it off and hold her accountable so that we don't have to keep coming back to court. That's how I talk to that judge. Can you argue factual errors on appeal? That's what I was saying earlier. No, you can't. The facts, whatever the judge said is true, is true. You have to argue misapplication of the law, or ignoring the law, or not applying the law right, or going above and beyond the law and abusing discretion. If that doesn't make sense to you, you need to get a consult with me, because it's a tricky thing that a lot of people don't understand. The finding of facts are the finding of facts in the Court of Appeals too. They will not change that because the judge had a chance to see you in person, watch your decorum in the courtroom, and all this other stuff, and see the evidence. And so they defer to the judge. The judge got the findings right. You're an alcoholic. You're a child abuser. You're a domestic violence perpetrator. That won't change on appeal. Findings of facts are verities on appeal. They won't change that unless there's one rare exception, and it's very hard to prove. There has to be overwhelming evidence in the record to the contrary, or a lack of any evidence that supports that finding that no reasonable judge would believe. It's a very high standard, but you can go for it. But you have to understand the premise of going to the Court of Appeals and what it really says, or where they start off. They will not disturb the facts unless there's an exception. But you got to find the case law in your state that says that. In Washington State, it says the finding facts are verities on appeal. They will not disturb the finding of facts, aside from, with the exception of substantial evidence in the record or lack of substantial evidence in the record. So you got overwhelming evidence that contradicted it and the judge just ignored it in their bias, or you have underwhelming evidence that supported that finding. They didn't really have anything. They're just believing somebody's word or whatever, that you're a domestic violence perpetrator. Okay, I'm going to leave it here. I'm going to have to get up out of here. Thanks for joining in and following. Those of you really putting up a fight, keep up the good fight. If you need a consult or you don't understand a lot of stuff still, then you do need a consult. You can get a consult with me. Look for the phone number in the description below. Go to my flow page. It's a one-touch button to call me. You don't got to memorize my phone number. Call or text me. The fastest way to reach me is to send me a text message. You say, hey, James, I need a consult. I'm available tomorrow at 3 p.m. Eastern time. And tell me where you are. I got people who they'll go back and forth with me 40 times. They don't even, and I'm saying, what time zone are you in? I need tomorrow at 1. Or, well, I got a funeral I got to attend. So maybe next week, maybe I could check back with you. And they tell me their whole itinerary. Just tell me, know when and what you want to talk, and just text me, and you'll get an appointment right away. Or you'll get it set up right away. And I do ask for payment to lock in an appointment because I get no-shows all the time. I had like 4 this week already, because I forgot to ask them for payment, so they don't feel like they're obligated. I woke up early on Sunday. It was late morning Sunday, but I was up all night Saturday. Woke up early for a guy. He said, I didn't know about your payment, and I'll talk to you now for free if you want to talk. I'm like, no, dude. So I do ask for payment to lock it in. You got to trust me like you got to trust an attorney. Or you can, let's say you want to get an appointment, but you can't do it until Friday at 5 p.m. Eastern time. That's 2 p.m. West Coast time, my time. You can always check in with me. You don't want to pay that far out because you don't trust me yet. You can wait till Friday and say, hey, are you available at that time? I'll say, yep. And then you pay me, you lock it in. If somebody else wanted that and they pay me, they get it. Just the nature of the business, because I've had so many no-shows. If guys weren't flaky all the time like that, I mean, I probably have like 15 to 20% of scheduled appointments or requests for appointments, the guy flakes out on me. So I have to make sure I'm getting up earlier, setting aside my time, because there's all kinds of other stuff I could be doing with my life. I got an elderly mother who depends on me. I got a sister with Down syndrome who depends on me. I'm her backup guardian. I live in the same town as my mother. My daughter still depends on me. And, there's a couple other people that I look out for, and then I'm trying to build, I just had to start all over with my TikTok. So I always got stuff to do. And there's a major project I'm dealing with too. So even on weeks and days that I don't have appointments, I have other stuff I could be doing. So if I'm going to postpone other stuff, or even my own personal downtime or my sleep, if I'm going to postpone that for a consult, I got to make sure that the consult's going to happen. So how much is it, right? I charge $80 an hour right now. And if you want to do initial consult with me, is never less than an hour. So I do initial consult is up to 90 minutes. If your brain's exploding in an hour and 20 minutes, you might end it or whatever. So I do a flat fee of $100. So it's $20 off the first consult, but it's got to be 90 minutes, because there's no way somebody who calls me the first time needs less than an hour and a half with me. And people are still going over that. Like the last 4 or 5 appointments I had, guys went over 10, 15, 20 minutes. Like, one more question. And sometimes they're mad at me for interrupting them because I want to get to the point and they want to ramble on about stuff. Then they really want to get their questions in at the end. So it used to be an hour, and everybody would go over an hour and 10, hour 15. And I can't afford to be having 15 minutes stolen here and 20 minutes stolen there. And especially when there's people right behind those consults. So I'm $80 an hour. The rates are in my flow page. Everything that I have to offer you, or free stuff, or my store, my social media links, it's all on my flow page, which is like a link tree. I used to have a link tree, but they booted me off because I said something blasphemous about COVID. So yeah, so $80 an hour. First consult is 90 minutes, up to 90 minutes, or a flat 100. And then after that, you can do follow-ups in 30-minute increments. A lot of people do that initial consult, and they do 30 minutes here, 30 minutes there, 30 minutes there. So that'd be $40, $80 an hour. Oops, wait. It looks like I missed a question. Is filing documents on the day of trial despite a 60-day deadline on application of justice a misapplication of justice? There's a lot of stuff that goes with this. For one, the court has rules and deadlines to make sure that people follow along and meet deadlines. Think about this. You have to always think outside the box. What are we doing here in court? What's the overall goal? The best interest of the child. If I miss something and I bring evidence the day of trial, who does that harm? Nobody. It's harmless error. It's a simple mistake that nobody is prejudiced by. That's something you should have in your back pocket. I talk to people about having reasonable person in your back pocket. There's also having in your back pocket this thing about prejudice. You go to court and say, Your Honor, if I don't get more time or a continuance, I'm going to be severely prejudiced. Or I go in there and say, I got this other declaration. Let's know I'm doing a motion hearing. I got this declaration from somebody else. I just handed it to them. It's only 2 pages long. They read it in the hallway. There's no harm or prejudice they suffer from you admitting it. We are here to do what's best for the kids. Are you going to leave out evidence because of some technicality and deprive the court of a full... Remember I talked about duty of care at the beginning? Or if you didn't see this, go back and watch it. The judge has a duty of care to make a full inquiry into the welfare of the children. Has a duty of care to do what's best for the kid. Has a duty of care to look in all the evidence. If you have a trial with a murder, the defense has a right to present all kinds of evidence, like a receipt that he was at Starbucks on the other side of town when the murder was happening at Burger King on the north side of town. You can't say, oh, I don't want to hear that. That's a technicality. If that might get him off, then justice will be served. Now, this is where case law is important. There's probably no rule out there that says, here are the rules, but we can waive the rules if there's not that big of a deal. In Washington State, there's a couple of cases that talk about the local rules. There's the law that says the court has to consider the welfare of the child, which parent is on drugs, which parent is mentally ill, which parent has abandoned, or which parent is more likely to facilitate a relationship with the parent. The court has to consider those. That's a law that the judge has to follow. The local rules of your county are, here's a technicality, get this in 14 days before trial or 12 days before a motion hearing or whatever. That's a rule to abide by. Just to keep order. That's not a heavy duty rule. That's a bright line thing. Oh, if this is violated, then we can't let them violate that because that'll be totally due process violations and the child, the child's safety is at risk. No, the child's safety might be at risk if you don't allow some evidence in that shows what a mentally ill monster the mother is or whatever. So there's case law in Washington that says the courts may waive their local rules in the interest of justice. As long as there's no harmful prejudice to any party or it didn't harm a party. If I'm going in as a pro se and I hand something in, no harm, no foul, Your Honor, they're not severely prejudiced. This attorney has 40 years experience. Do you think they're caught off guard by anything? If they're complaining about it, that means they're too incompetent after 40 years to know how to do a trial. They've done 1 million trials. That's bullcrap. They just don't want you to see this evidence that shows that the mother's an alienator or whatever. So you want to know... If it's not plain in the law or in the rules, you want to find case law on it, or you want to talk about the overarching doctrines and policy of the court, fairness and equity, a right to a full fair hearing, a right to be fully heard. If I'm going in there and they started the case against me, the mother's trying to take away my parental rights, that's the constitutional right they're trying to take away. What's more weightier? The Constitution, Troxel versus Granville, my rights, or some little piddly little local rule that says get it in 60 days before trial? But there's always attorneys bringing in exhibits the day of trial or during trial or on day 2 because somebody said something, they went and dug up a contradictory piece of evidence to try and impeach their credibility. So that happens all the time. But you want to know, you want to understand the basic, maybe I should do a video on this, the basic overarching leading doctrines of the court. Fairness and equity, due process, the right to a fair hearing, the right to notice, the right to be fully heard, which means be fully prepared. That's the fundamental fairness doctrine. I have a video on that. So now that I said that, maybe that's a good idea to jumble all those together, like the overarching doctrines. Objectivity or well, I guess that falls under. There's due process because you have a constitutional right at stake. You have a right to be notified of a proceeding and a right to be fully heard. And being fully heard is laid out in case law only. So the fundamental fairness doctrine says you have a right to notice and a right to be heard. But case law or common law over the years has said you have a right to be notified of a hearing and have ample time to prepare a defense. Your life with your kids is on the line. That's a constitutional right. They need to afford you time. And if the judge says, no, it's not that big of a deal. Yes, you're telling me the Constitution is not that big of a deal. What kind of treasonous hater are you? Or traitor are you? How dare you say it's not that big of a deal? See, when you know your constitutional rights and that this person is working for you, I pay taxes for you to do your job and serve we the people. And you're supposed to do it fairly and objectively, and you're supposed to do it under oath. You're violating the Code of Judicial Conduct. You're violating your oath. You're violating the Constitution itself and the fundamental fairness doctrine and a right to fair and equitable hearing. See, when I understand the right to a fundamental fairness doctrine and a right to be fully heard, I can argue that 20 different ways as long as I understand, in basketball, if you're you can only take one. I don't know what it is now. It seems like it's 4 or 5 steps. But in the NBA, it used to be you could take 1.5 steps. When you're dribbling down court, pick up the ball, you can take 1.5 steps before you lay the ball in or dunk. If that's the rule, I know the fundamental rule, 1.5 steps. If I see somebody take 2 steps or their pivot foot slips, I'll say, look, he slipped his pivot foot. He took 2 steps. He took 3 steps. He picked up the ball at the top of the key. There's no way that he got there without traveling. He walked. I could say it 10 different ways because I understand the rule is 1.5 steps. If I know I have a fundamental fairness doctrine and a right to prepare and be ready, I can say my fundamental fairness doctrine was violated because I don't have time to be ready. They blindsided with this at the last minute. Even if they did it on time, they overwhelmed me with so much evidence. I don't have time to prepare for that. I need a continuance. Or they put all the stuff together out of order and shuffled it on purpose, so I had to put extra time in and I'm not ready. And since the fundamental fairness doctrine is a constitutional thing, you have an oath to uphold that. So you need to follow that or else we don't have due process and we don't have a fair hearing. And I understand this court is a court of fairness and equity. And you can't even appear to be unfair or biased against me. If you do that, the Code of Judicial Conduct says that you need to maintain the public's confidence in the judicial system or society falls apart. You are destroying and shattering the confidence if I don't get a fair amount of time to prepare for the hearing. And I've never gotten a continuance before. Here's my chance to get a continuance. I asked for it. They got a continuance. So obviously you're being unfair. So I can argue this a million different ways when I know just 2 principles like that. So you got to know the governing principles. And if you're late in the game, you got trial coming up or hearing coming up, you should get a consult with me. You don't want to sit around and wait and hope that I get another 10 or 15 minute video that covers what you need. Get a consult. Let me make sure I didn't miss anything else. Okay, so I did. It's filing a document. Okay. Okay, my final order, one of the findings is I made a poor decision to call my child by their middle name. Does this finding mean that I should not call her by her middle name? Or is this just an opinion? That's an opinion based on, that's where you ask the court, where do you get that from? Where are you see, somebody asked about all the science and the court wouldn't allow the science in. Where's the judge getting that from? Because if the judge is getting it from, well, I just know that that's bad to call a kid by the middle name. If the judge is saying that, he doesn't have any science backing it or expert opinion by a child psychologist or therapist, then the judge is testifying. So the judge is testifying. He's not allowed to testify. So that's inadmissible testimony. That should be stricken. So that should be stricken on a reconsideration. And you tell him that's another motion for reconsideration for reversible error. And judge testifying and making up his own law, rules, and facts and treasonously violating his oath. The fact that if the mother didn't like you calling the middle name, he's biasly going off the mother because there's no science, no data, no expert testimony. Nobody is testifying that that's even harmful to the child. I'm a parent. And this is where you need to know where the judge's job is. He needs to stay in his lane. You need to stay in your lane. I would do a motion for reconsideration for a judge not staying in his lane. And he'll be like, what the hell is this talking? You didn't stay in your lane. You're not allowed to testify. And you're not allowed to tell me how to parent my child. If I think it's cool to call my kid by the middle name or a nickname or whatever, we call kids nicknames all the time. My daughter, I called her Baby Bear because she watched this cartoon with different bears. It wasn't the Bernstein Bear, it was somebody else. And then one of the kids said Daddy Bear and the other one said Baby Bear. And so my daughter started calling me Daddy Bear. So I called her Baby Bear, and it stuck for like years. I even call her like that when she's an adult sometimes. But is the judge going to tell me you can't call her a nickname? See, when you take what they're doing and then you apply the logic to something else that everybody does, you make them look like a stupid, utter moron. This is what people need to do. This is what I'm not saying this guy is, but my gender and the lawyers are a bunch of punk ass bitches, and they're scared to do stuff like this and jam the judge in the corner. Like, how dare you say I can't call my child by the middle name that we both agreed on? You're telling me I can't do that? You're violating Troxel versus Granville, because I have a right to the care and custody and raising my child the way that I want without government interference. You are being a fascist and overstepping your bounds and stepping out of your lane. You can make decisions on which parent can make this, has decision-making authority, what the visitation schedule is, but how dare you? You better not ever tell me how to raise my kid again or what names I could call them. That's insane that you have the audacity to even do that. Why are you doing that? Because the mentally ill mother says she doesn't like me doing that. Even though I did it before we brought, or whatever. So. Yeah, so adult supervision said that's pretty stupid. Adult supervision said, was it Song of Solomon? I served my ex and just filed for default because she didn't respond. Any advice on that? Yeah, you should go for default. But you need to know all the case law in your state on default. A lot of judges won't give a dad a default because they don't want the mother to win without knowing. And you need to know, like I had a guy who won by default. It took him like 3 months because the mother never answered. And he went to court and they're like, well, I don't know. You got to go and do this. And they made him jump through a hoop and jump through a hoop and jump through a hoop. And I told him, dude, tell him what the case law says. He's like, oh, I don't want to do all that. So he just jumped through all their stupid hoops. And they gave her chance after chance, and he got default. He got custody of that kid. And that guy came to me. He was literally crying. That was about 15 years ago. And that guy came to me crying, and he kept whining and crying every time I met up with him. Dude, you got to grow some balls and fight. I know it sucks, but you got to do that. And he did. And he still thanks me to this day. He needs to knock it off because he's the one who went in there and did it right and fought. He had some bumps in the road before he got the default. He had a fighter halfway across the state of Washington. Then he filed in the greater Seattle area. He got her by default. And then he had to jump through some hoops, but he finally did it. I give credit where credit is due. Once you do this stuff, you will get props from me all day long. And it has very little to do with me other than I gave you the information. You still have to do it. If you have a coach who tells you, work out like this in the offseason, let's say there's a pro basketball player who's retired, and he teaches a kid, like, you're 6'1", you're playing center in high school, you're going to play guard in college and in the pros if you ever want to make the pros. You better start shooting three-pointers and do this and that. You need to shoot 500 three-pointers a day. You need to shoot 500 mid-ranges. You need to work on your dribbling drills for an hour and do this and that and that and that. If that kid does that, he can say thank you to him, but that guy should be telling him you put in the work. So on default, you need to know all the case law on default, because the Washington case law says if they don't answer and they don't respond, they're not entitled to notice. And you'll go in and the judge will say, well, did you notify her? I don't have to notify her. Case law says this. Well, I want you to notify her. Well, you're violating the higher court precedent. You don't have an option. You have to find. So you got to know what the case law says on default. Allen Iverson started all that travel business, James. I saw plenty of traveling when I was younger, though. He's more famous for carrying because of his crossover. But I served my ex and just filed for default because she didn't. Okay, that's the same. I don't know how I got back up there. I'm just trying to make sure I didn't miss anything. I served my ex and just filed for default because she didn't respond. Any advice on that? Okay, I served my ex. Okay, I'm sorry. I'm reading the same thing. I'm getting tired now. Shay, only the devil would say reading scripture is inappropriate. Yeah, these are a bunch of demon-possessed psychotic weirdos. When you walk into family court, it's like the Twilight Zone. The judge told me about the middle name and calling and everything in his judicial opinion. My lawyer, who I fired, said he is allowed to do that. In his judicial opinion, is not. The lawyer's retarded. How did the judge come to the conclusion that you can't call by the middle name? Because that has to be harmful. You need to pin the judge down. Where are you getting the idea that it's harmful to call a child by the middle name? Nobody testified to that. Nobody expert. So this is where your attorney should have done deductive reasoning. Nobody testified to that. No evidence was presented to the judge. The judge made this conclusion. He was basing it off of his own personal testimony. That wasn't a conclusion based on evidence. The judge sits back and pretends that he knows nothing in life, and you present him with evidence. And then he has to look at the law and see whether you made a good argument in light of the law. He has to look at all the factors in the law. There's no factor in the law that says you can't call your kid by that name. So where did he get that from? He made it up himself. That's an unreasonable abuse of discretion. So you call it that in a reconsideration. Do you have a link where I can study up on the law for default? I don't have any. You have to just Google. If you're in Minnesota, Google Minnesota Supreme Court default. Minnesota Court of Appeals default. Whatever state you're in, you could search like that. And then you might find attorney blogs, or you might find, you'll see popping up, here's attorney so-and-so, attorney so-and-so. Williams versus Williams, Minnesota Supreme Court, 1974. Click on that and read that. And within that case, they'll talk about other cases. You just dig. There's some search engine out there. In California, I have a link to Lexis in my flow page. In Washington, I have a link to Lexis in my flow page. I had a link to another state, but that one was kind of weak and messed up, so I deleted that. But you can Google stuff. There's times when I have a consult with somebody, and they're like, I got this issue and problem. I'm like, let's see if there's case law in your state. And boom, in 5 minutes, we found the leading case law on that issue. Sometimes it's like that. Sometimes you got to look for hours or days. Okay, looks like I'm caught up. If any of you got anything out of that, please consider a donation. If you think it's worth a few bucks, $5 or $10, I may start asking for that because people are getting hundreds and hundreds of dollars hours, hundreds, like $400 an hour worth attorney information out of this stuff for free. And if everybody just pitched in $5 or $10, I could do more free videos. If you go to my flow page, that's ways to pay and donate. Or anybody watching this later on or watching in my videos, you get anything out of it. If it's a 30-minute, like, I don't know how long this is. This is almost 2 hours. That's $800 if an attorney sat down and did this with you. So I'm not asking for that. But if, maybe I'll do some lives with I forgot what they call them. Super chat. I don't know if they do that anymore. But I've never set that up. But if that'd be great if everybody wanted to do that. And that's all I did. Because, I go days and days without consultations sometimes. And days and days without people buying stuff in my store. So, and I'm giving away all this free information. But I just thought about it recently, like, You know, I got what 9,000 followers on YouTube. I mean, if it just what if and you'll never get half of people. Like you get 1/5 of people contributing and caring and doing something. What's that? 2,000 people. If 2,000 people gave $2 every month or something like that, then I could do this stuff for free all day long. So maybe I'll have to set something up like that. I don't know. But I watched so many of your videos and will be calling you for a consultation soon. I'm ready to go to war and beat this rigged system. Good. Okay. All right. You guys hang in there. Keep up the good fight.